Now, thanks for the help of a lady student last time, and she has kindly corrected me on a mistake that I have made in the assignment. It's a very interesting case because, I was mixing up on the action number. One case I handled is a kind of 1187 or something like that, and this one is 1787. So I get all confused. And then having checked it, so I have made the correction and have uploaded the assignment as well as the question. So I think the school has already uploaded it this afternoon. I don't know whether it is true or not. If you can't find it, or if you still have problem, then probably just wait 1 or 2 days, and it should be all right. So you should have the case of the Indian form, and then on the Chinese will. And that is exactly the judgment which I want you to follow. Now, the other thing is, on what we talked about last time on the intestacy. Now, I have briefly given the example to the class for surviving family members, which we call the next of kin. And in order to test our understanding, just to reflect the complexity and the various situations on testate and intestate, as well as the focus on the contingency interest in terms of child. I've also mentioned to the class about the possible confusion on the term issue. Primarily, issue means the lineal descendants, and then by the same token, it also include in the various aspects in connection with the statutory trust that we are going to talk about earlier this evening, like the issue of the siblings, like the issue of the uncles and aunts. So in doing the revision, please make sure that your mind should be as clear as possible, and don't get it confused. I've also mentioned to class about the testate and the intestate difference in terms of the contingency. Now, just to refresh our memory, so I gave the class about this example. Someone died without a will. He died intestate. And then survived by spouse, issue, and parent. Okay? On the date of the death of the intestate, the issue was only aged 2 years old. I follow strictly on what I've given to you last time, so that you can keep track of it. And then 15 years later, the kid died at the age of 17. He never made it to 18. In between, 2 years after the death of the intestate, the parent died. So in other words, I've given you a scenario of day 1, intestate died. Day 2, 2 years later, the parent died. And then day 3, it is the 15 years later, the issue died. Just to illustrate to us on the contingency nature of the rule of intestacy in terms of inheritance. So if you are able to understand this thoroughly, then you should have no problem dealing with the various questions that I've set out in the past several years on part 2. Because it is exactly the kind of situation that I want my students to be well aware of. And in practice, it is something that your client will find it surprising that, In fact, this is a situation, Mr. Wong. So you guys should be able to comprehend this and tell your clients about this point. So I briefly repeat again what I've said last time. It goes like this. So day one, interstate, spouse, issue, parent. Now, share entitlement would only arise on two factors. Number one, there is a surviving spouse. Number two, the residual estate. The residual estate is big enough for payment of the three components which is given to the surviving spouse. One, personal chapters. Number two, the statutory legacy. And number three is the interest. So only if there is a balance, then there is share entitlement by the spouse with either issue, parent, and whole blood sibling. So furthermore, we illustrate on the contingency nature of the issue. Then we say, at date of death of the intestate, he was 2-year-old, and then he died 15 years later at the age of 17. The fact is given in order to show that he never made it to 18. So he died a minor. And because of this interstate issue contingency nature of entitlement, so we can say when he died at day 2, aged 17, it is presumed that he never made it, with a retrospective effect back to day 1. That means, assuming the residual estate is big enough, and assuming also no further rule on other remoter issue, then we say the intestate is deemed to have died counting at day 1, survived by surviving spouse, and this time skipping the issue, leaving the third in a row being escalated into second, being the parent. So in other words, at day 1 is deemed that the intestate is survived by spouse and parent. So we just recap what we started earlier on about this share entitlement. Estate big enough is only 3 types of next of kin only entitled. So it's issue, parent, and whole blood sibling. Issue deemed not to have existed at day 1. So parent escalated, now this become a share entitlement of surviving spouse and parent. So even though the law says that, okay, 2 years after the day of death of the intestate, the parent died. Nevertheless, this 2-year period is significant to establish the fact that here we are, we have a parent who survived the intestate. And therefore, since his entitlement is not contingent in nature, he enjoys an absolute entitlement. It's just a matter of distribution as to when the estate is being completed in terms of collection and paying off all the indebtedness. Well, he died too soon in order to actually enjoy them, but he died long enough, outlived the intestate, so there is inheritance payable to the parent's personal representative. Then we ask, who will share the estate with the surviving spouse? The answer is, well, it should be the estate of the parent who died 2 years later. But then, It all depends on he died with or without the will. So if he died testate, you look at the will. If he died intestate, then you look at the rule of intestacy. Now, in a situation like this, there will always be situation of, like a circular game. It goes back to the original intestate. And then, the circle goes round and round and round until you can establish who is or who are the next of kin in a position to enjoy the inheritance. So that is the kind of thing that you should be able to appreciate. And the other thing is, okay, if at age 3, the issue died at 17, we say the law in terms of inheritance, he is deemed to have died with a retrospective on day 1. That is only in terms of inheritance. This is without prejudice to the kind of benefit that he has been enjoying from day 1 until day 3 when he passed away. It may always be possible that during this interim period from day 1, he was 2, to day 3, he was 17. During this period, he will be subject to the discretionary power of the personal representative. Here means the administrator, in order to provide out of the estate some kind of assistance to the issue who has now died at day 3. Now, since this kind of financial assistance to the issue died at day 3, what has been paid to him, number 1, he cannot give a valid receipt. Number 2, he has lost his entitlement. So, is there any claim for clawback? The answer is no. Because all these possible payment by way of possible advancement, by way of possible maintenance, are just part and parcel of the regular trustee power, which is borrow and copy and form as part of the statutory trust that we are going to talk about now. So all this given, no problem, as long as he's still in his contingency, then he can get all this medical care, school fee, other kind of benefit, although it doesn't come in as a kind of inheritance. So this is the kind of stuff that we have to bear in mind about stuff like this. We should refresh this idea as we move along, but this is a very important element in terms of rule of intestacy in Hong Kong. Okay? Now we come officially to this term, statutory trust. This is another very confusing theory or doctrine within the rule of intestacy in Hong Kong. The law in Hong Kong is slightly different to the present-day law in England. So for those of you who are making reference to the UK text or textbooks, be very careful on this. We are still following the old English law. The other thing is, because of the naming of this doctrine makes it so confusing that people get confused all the time. Here, we mean statutory trust. So the statute means Cap 73, IEO. Number 2, the statutory trust with an S at the end. That shows as an emphasis that there are various components. In fact, there are altogether 4 components in this statutory trust. then let us remember this as a unique statutory provision under the rule of intestacy, which finds its way in Cap 73 and is contained expressly under Section 5 of IO. The whole purpose of this statutory trust is to provide some statutory means or ways in order to enable the estate administration on intestacy where there is minority interest. The basic difficulty is when a minor is minor, then he is not able to give a valid receipt. So there is a waiting period. Number two, there is this uncertainty in terms of the contingency. He survived for quite a while in the example that we have just cited earlier on for 15 years. But he may never make it. We don't know. It's all a waiting period. So how are we going to do? There are two dilemmas. Number one, you have to wait until the date has arrived, meaning the age of majority. So you have to hold on to it. It's a kind of wait and see. Number two, there is always a need on the next of kin, to require financial assistance from the estate. Now this kind of assistance is not necessary on the Cap 481 that we are going to talk about at the later part of this lecture. It's separate. But it's all within this rule of intestacy. So on the one hand, you cannot give a receipt. On the other hand, you need something to be given to you in order to support you out of the inheritance. So Section 5, Statutory Trust, comes in order to try to solve this problem. So they word it in such a way that this is not a kind of interim distribution of estate. This is not. But this is something by nature as a discretionary power. So the administrator has the authority to use part of the estate in order to provide various stuff to deal with this minority waiting period. So that is the whole nature. And since this is a power, the need for a valid receipt, this issue is override. You don't need it. There is no need for any receipt. Like if you need the school fees to be paid, then you may pay to the issue, you may pay to guardian, you may even pay to the third party, the tuition, the school, the educational institution, whatever, either directly or indirectly. There is no requirement for any valid receipts as long as this is a power on the part of the administrator to consider. Yes, I need to provide for this kind of payment during this interim period, and this is not interim distribution at all. So, for some aspect, so they borrow something from the trustee ordinance in terms of maintenance, in terms of advancements, so on and so forth. So we need to remember the nature of this kind of statutory trust. There are four aspects in the earlier slide, the first slide that mentioned last time, about who are the person entitled to inherit on the intestacy, there were 9 items, if you recall. Item 1 to item 8 are the person entitled. They are family members, possibly, entitled to inherit. And item 9 is not. Item 9 is only where bona vacantia comes in. Nobody owns the property by way of inheritance. Everything goes to the country, and in Hong Kong, go to the government. For item 1 to item 8, they are close relatives, and the legal jargon is next of kin. So they are potential beneficiary on intestate. And if in fact it turns out that they are entitled to inherit either as a class solely or on a share entitlement as we have just discussed, then we call them next of kin with beneficial interest. So only next of kin with beneficial interest is entitled to apply for a grant, which we shall discuss later on. Now, the thing that we need to remember is, well, of the 8 items, it was complicated by one element of whole blood and half blood. Remember? Whole blood and half blood is something that concerns only the siblings and the uncles and aunts. So apart from them, the rest, so spouse, issue, parent, grandparent, uncles and aunts. So grandparent, parents, sibling, uncles and aunts, and issue and surviving spouse. Now, the thing that I want you to remember now is to note that statutory trusts do not apply to all of them. Statutory trust, by its nature, is only to give assistance for better administration when there is minority interest. Once you know the background, that you understand why some other items, some other next of kin, statutory trust is not extended or are not extended for the clear reason that certain type of next of kin are deemed without the possibility of minority interest. So in other words, by the fact that if they are next of kin with beneficial interest, they cannot be a minor. If they are not minor, statutory trust will not be applicable. Therefore, it's easy by way of the process of elimination. Easy, spouse. Okay? So we accept that a spouse would not be a minor. By the same token, the parent would not be a minor. Applying the same analogy, grandparent. So all these are just common sense. They cannot be under the age of 18, otherwise it would be a joke. So with this in mind, then now you know why is that the statutory trust is only applicable to the other types of next of kin. Issue, possible minor. Siblings, possible minor. Uncles and aunts, possible minor. So this is for this reason that you can see that it only applies to here, the various type item 2, 3, and number 1, 2, and 3. The further points to note in this slide is only out of the 4 components of this statutory trust, insofar as the child as an item, only the child is subject to all 4 components of this statutory trust. whereas for the others, 1A, 2, and 3, only the 3 other types of statutory trusts are applicable, excluding the inter-vivos gift. IVG, I use it to stand for inter-vivos gift. So take a look, do bear in mind. These are the 4 types of statutory trust: per statutory rule, power of advancement, the Hodgepodge rule on inter-vivos gift, and power for infant use of personal chattels. Item number 3, the Hodgepodge rule is the rule against double benefit. That is to say, if for some reasons you got benefit elsewhere, then the rule of intestacy will assume and there shall be some adjustment in order to make things equal. So that is the whole thing about the Hodgepodge rule. So you cannot benefit larger to the prejudice of the others. So that was the intention. So this is the per statuis rule. Minor to take only upon attaining 18. Issue of predeceased issue to take by substitution equally. And issue, meaning remote issue, not to take if the parent is alive. So the nature of the per statuis rule is only to enable if some issue having higher priority should predecease the intestate. So if he failed to survive the intestate, yet his own lineal descendants are there and survive the intestate, so those who survived it, the intestate will be able to step into the shoes of the deceased next of kin in order to benefit. And if there is more than one of them, then they share equally. Now, having said this, the term equally must be taken at the proper perspective, because the term that they use is per stock, S-T-O-C-K. You look at the wordings in section 5. You look at the wordings in section, first of all, section 5 of CAF 73, or the similar wordings of section 23 of the Wills Ordinance. This kind of remote issue under the per statuis rule here on intestate presuppose that there is the possibility of different generations. Meaning, if a son died, leaving 2 of his daughters, and then one daughter survived, another daughter died, leaving further remote issues, then all this, you have to go one layer to another layer. You started with the first layer with 2 kids, each take 50%, and then you go further down, so that 50% and then ultimately entitled by 2 younger generations, then will be 25% each. and you go further down in the pyramid, then although we say that they take equally, then we say according to their stocks, according to the generation that they belong. So on a pro rata basis, on a pyramid, then goes all the way down. So this is the per stirpes rule. Now, strictly speaking, per stirpes rule only apply in the rule of intestacy and is part of the statutory trust. And it's also this major impact of the per stirpes rules. So people sometimes may think or may say that, well, affected by the doctrine of statutory trust. In fact, what they mean is only by affected by the doctrine of the per stirpes rule out of the statutory trust, because this is the most material in terms of having inheritance to be properly distributed. Rule B is this advancement, maintenance, and the related concept of accumulation of surplus interest. All these are strictly speaking borrowed from the trustee ordinance, Cap 29, so that the kind of possible remedies or assistance granted to the beneficiaries under the trust as provided under the trustee ordinance is being extended to cover this minority interest possible dilemma. No need to give any valid receipt. Well, advancement usually is money coming from the capital. Maintenance usually is money coming from the income. And then there is surplus income that is meant to be accumulated. So all these are concepts borrowed from the trustee ordinance. So the major things that would happen out of this part of the statutory trust is this money given to support the minors. As I've told the class, there is no clawback provisions. Given to you for your education is payment to you. You don't take it as a debt, and you don't take it as an interim distribution. So all these are just discretionary items. The third rule is the hodgepodge rule. Look at the bottom of this slide. There are in fact 3 hodgepodge rules. There are in fact 3 hodgepodge rules. But it's only the first one forms part of the statutory trust. So if we understand the hodgepodge rule, the rule against double benefit, or on intestacy, so you see that it will include money given in the lifetime, inter vivos gift, inheritance received from outside Hong Kong under the rule of intestacy. That means if the intestate happens to have assets outside Hong Kong, and yet by the rule in the foreign jurisdiction, there are inheritance given to this particular next of kin. So he benefit once overseas, outside Hong Kong, out of the rule of intestacy. And then if he were to benefit again in Hong Kong, then adjustment will have to be made in order to reduce his entitlement here in Hong Kong. Remember, this is only intestacy. So this is one example, as an example to show why it is always good to make a will. Testate payment, irrelevant. The third hodgepodge rule is the partial intestacy. So you have a benefit under the will, then there are some provisions that your entitlement, or in the case of spouse, your entitlement under the statutory legacy will be reduced. So these are the three hodgepodge rules. The similar nature here is the worst case scenario is no inheritance out of the Hong Kong estate. There is no requirement of overpayment to pay back as a kind of compensation. So if you receive a lot, more than what you deserve under the rule of intestacy, then, well, you say you don't have a share for the Hong Kong rule of intestacy. But you don't have to worry about clawback and pay back the kind of stuff that you have received that has exceeded your Hong Kong rule of intestacy entitlement. So that is the bottom line. What concerns us here as the statutory trust is this inter-vivos gift to the child. Two things needs us to pay attention. Number one, this kind of inter-vivos gift must be substantial. Normal education, maintenance are excluded, even though it may be substantial. So the usual kind of area that will be affected here will be gift on the occasions of marriage. So when the son got married, the father said, okay, I buy you a house on the occasion of your marriage so that you and your wife can live there. This is one. The other is a typical item of advancement specifically given by the intestate father, for instance, to the son in order to promote or enable the son to get some kind of a change in his status. The typical example that you can find in the textbook is where the father agrees to buy a partnership to enable the son to become a partner in Wong Sum & Co., my firm. For example, you pay me $2 million. I allow your son to come in and to become a partner of my firm, and in order to get the sharing, the additional sharing of profit. So this becomes an example of advancement. So this is one thing we need to remember. The other thing that we need to remember is this inter-vivos gift rule against double benefit is only limited to a gift to the child only. So any gift given to the remoter issue, or meaning the remoter issue even of lineal descendant. You give it to your grandchild, your son, the son of your son, no problem. Then if you make a gift here, you give it to your brother, your mother, And any other next of kin, again, not caught by this rule. So this rule only affects gift in the lifetime to the children. So sometimes you see example in a test of this nature asking us to discuss about this hotspot rule when the deceased has given various kind of similar payment but to different types of next of kin. That would only be trying to serve to enable us to discuss the differences and the unique nature of this kind of inter-virus gift, only limited to child. If the gift is given to some other next of kin, if the gift is to the remoter issue, no, not affected. The consequence of not affected by this rule means he can keep the inter-virus gift. He can then again share on the inheritance. So nothing affected by this double benefit. The final element before we move on, still on this rule, is this is subject to contrary intention. That becomes a matter of evidence. Remember, we are here to talk about the inter-virus gift. Well, unlike a will, you can have the necessary declaration stated in the will. But this is rule of intestacy. So there is nothing that you can see in terms of a testamentary provision. So in order to get around, you will need to provide very clear evidence, generally at the time of payment. So when I got married, my father said, son, I will give you $2 million. You buy a flat in Tai Bushing as the down payment. And I would like to stress that if I were to die later without a will, this will not be affected by the inter-virus hotspot rule. That will be one example. Okay? In order to show that there is actual contrary intention. The fourth rule, again still on the statutory trust, is the power on infant use of the chattels. So the law allows the administrators to enable personal chattels to be used and enjoyment by the infant, same meaning minor. The thing to remember here is it may be contradictory if we are talking about the share entitlement. If you recall, let's say this is a spouse and child share entitlement. We said the spouse is absolutely entitled to the personal chattels. If the spouse is absolutely entitled to the personal chattels, I don't think it would be up to the administrator to say, look, notwithstanding your absolute entitlement, I now decided to allow your son to use the personal chattels. The two do not stand at the same time. If it is to be given to the spouse, it is to be given to the spouse. So probably the only scenario that this can be utilized is where there is the entitlement amongst the class of issue only. When within the same class of issue, some of them are adults, some of them are minors, so it will then be up to the administrator to invoke on this rule. But again, there is still a further problem because of the very difficult definition. It's not difficult, but it's very strict definition under IEO of the term personal chattels. If you're saying that administrator has a discretion, allow the personal the personal chattels to have use and enjoyment of the personal chattels by the minor, then if you look at the definition of personal chattels, when it is restricted to those chattels found in the residence of the surviving spouse. So how you can resolve this? It will be in practice a problem. So if you want to be very strict on this, this rule is very difficult to digest and follow because of all this problem. It has to be in the spouse residence. If there is a spouse, the personal chattel is to be given to the spouse. If there is no spouse, then there will be no personal chattels in the spouse residence. So all these are possible problems that one will find. But anyway, we are just to take notice that of this statutory trust is something created by the law, which is only Cap 73, to enable better administration when there are minority interests. So in practice, how this is operated, we don't really care so much at our level. So you just bear in mind that there are 4 possible components. The perstupis rule, the first one, is the one similar but yet slightly different on testate that we talk about section 23. So again, you have to be careful. Section 23 of the Wills Ordinance only concern a testate situation, whereas this perstupis rule concerns only the rule of intestacy, intestate situation. So please do note this. This is what I mentioned about the 3 possible hotspot rules under IEO. Number 1 is the inter vivos gift, meaning the lifetime gift that we have just discussed. Section 5 of Section 1 is within the statutory trust framework. The 2 others are outside. Rule 2, gifts under will, partial intestate, is not part of the statutory trust. This is provided under Section 8 of IEO. And this is the foreign entitlement according to the rule of intestacy as applicable outside the foreign place where the assets are affected. So in Section 8A, again, this is not part of the statutory trust. So if we are asked to discuss about statutory trust, only Rule 1 is relevant. Talk about this already. Okay, that's it. There are a further slides that I want to share with you so that we have a more comprehensive understanding of the rule of intestacy, the modern rule of intestacy. This is the spouse appropriation of residence. There are 2 types of appropriation. One is called the right of appropriation, RIGHT. The other is called the power of appropriation. The power of appropriation is the discretionary power of appropriation. It is a general power of appropriation exercisable by the personal representative, testate or intestate. Hence, I use the term personal representative. Subject to the consent of a particular beneficiary or next of kin, the personal representative is having this discretionary power to make distribution of estate by distribution in specie. Now, normally, in terms of the administration of estate, the general flow would be this: collection of assets, conversion into cash, if the asset is not already in the form of cash, pay off all the debts and liabilities, then you have the residue, and the residue is the residual estate, and it is this part of the balance, meaning it is this residual estate which will then be the subject of distribution to either the beneficiaries of non-residual under testate situation, or to the residual beneficiary who are the next of kin with beneficial interest under the rule of intestacy. So what we are distributing is only the residual estate, generally already converted into cash. But the law says, the law is provided by the common law and codified by Cap 10, Appropriate Administration Ordinance. Generally, whatever distribution in specie cannot be more than the entitlement, either testate or intestate. So the maximum would be the entitlement, cannot go beyond. So this is a discretion. This is a power by the personal representative. So I've given you the general rule on appropriation. But then, under the rule of intestacy, the law gives the right, not a power. It's a right on the part of the surviving spouse to demand the administrator in terms of transferring the interest in the matrimonial home in her favor. So I said this is a right. So this right of appropriation is not the same as we have just discussed on the power of appropriation. This right is limited only to be exercised by the surviving spouse, not any other next of kin with beneficial interest. Issue, parents, siblings, uncles and aunts, grandparents, none of them. They have no right to demand the matrimonial home. Then these are the following conditions. The matrimonial home is limited to the residence of the spouse. Number one. Number two, is exercisable only within the 12 months. 12 months is counting from the date of grant being issued. Number three, this can only be exercised during the lifetime of the spouse. And this is irrevocable. So these four conditions are fairly straightforward. You just follow the timeline, then it should be all right. But it is in practice the estate admin scope that we need to be very careful. One thing is about what kind of stamp duty needs to be paid or payable on the transfer of the matrimonial home. You know that it's a common phenomenon in Hong Kong. It is very common for DFA to be made, deed of family arrangement. Sometimes some of the members will say, well, I don't want my share, and then I want this particular species to be given to another designated beneficiary or next of kin. Very common in DFA. But then we have all kinds of stamp duty now in Hong Kong, so you need to know what to do. Because once you are getting a share of inheritance that has exceeded the right of entitlement, that immediately is liable to stamp duty. I'm now giving you to look at it as an option in your practice. If stamp duty is an area of concern, instead of signing the deed of family arrangement, we should give serious thought, if this is workable, by the surviving spouse to say, okay, I want to get the matrimonial home. So the whole residence can then be transferred to the name of the surviving spouse. And then this further right also provides that you demand the transfer of the matrimonial home that can exceed your regular entitlement. Simple example. Let's say the spouse entitlement is 2 million under the rule of intestacy. If the matrimonial home is 3 million, the general appropriation cannot be exercised because it exceeded the share of the spouse. DFA, you may need to pay stamp duty on the extra portion because spouse enjoy more than she is meant to take. Then, this appropriation is a third element that you may consider. Because the law can say, well, the surviving spouse is entitled to take the matrimonial home. The kind of magic factor is particularly relevant if the property market is fluctuating. Day of death, one value. Day of appropriation, market fluctuation. Then how soon you can do, of course there is a timeline, 12 months after grant. So this is the kind of decision that the next of kin will have to make up their mind. See whether it is more appropriate for the surviving spouse to take the matrimonial home. I don't have the exact figure. I don't know which is better. I'm just throwing it wide open to you for you to remember that this is an option. Okay? This is an option, and I know that ILD would require very detailed proof to show that this is a right actually exercise for this appropriation of the matrimonial home. Then you have to prove all this. And this is the legal framework to support such requests. The second thing that I need you to remember when you come to this stage, the provision under this portion of the IEO is not entirely absolutely correct, but it seems to be very arguable that the law says you want this appropriation of matrimonial home. The matrimonial can only be transferred by the administrators, plural. So if you're really thinking about the estate planning in a situation like this, in applying for a grant, now, we have spent some time talking about minority interest, life interest, on the need for more than one administrator. This is another scenario that we have to consider. If your client really has in mind about this right of appropriation, that it is always advisable to have two administrators in order to get yourself eligible within the statutory provision. Remember, under the law, there is no restriction or prohibition for more than one administrator, even though if there is no minority interest, even though when there is no life interest. So on the safe side, if things are possible on this, then remember, appoint two administrators. So if the surviving spouse is having the highest authority, then this is one juncture that we should consider on nomination of co-administrator. So you nominate a second person to apply for a grant of LA, just to have this in mind. So this is one illustration sometimes for us to note that why is that there are numbers which is deviates from the statutory requirement. So for LA, no minority interest, no life interest, you still have more than one administrator. This is the reason. Another reason, if you recall, how many attesting witnesses? I've told the class. 2 is the minimum, okay? But then why is it we need to have 3 or 4? Because there are gifts to attesting witnesses. You want to save the will and you want to save the gift as well. So these are the features that exceeded the minimum number as required by different statutes. Okay? Now we have this final concept on the rule of intestacy. This is what we call the rule of commorientates. If you guys are minded to study further from this module, you want to take the course into LLB. This will be a possible area that you need to remember. Rule of commorientates. Again, there are 2 different rules. The general rule of commorientates. Commorientates means people die together or at the same accident. And you don't know who died first. You don't know who died first. For example, both couple jump down from high rise, they die together. Another example, they go and travel and die in the same crash. They die together. In situation like this, then one would invoke on the rule of Camorra takes in order to decide on succession. In terms of succession, you will have to consider one, the general rule. The other is a narrow rule that applies only on intestacy. First, on the general rule. The general rule is this. He who is older dies first. Presumed to have died first. Okay? If all of us in this class, suddenly there is an explosion, okay? We all die at the same time. Now, Mr. Wong is older than you guys. Mr. Wong is deemed to have died before you guys and survived by all my students. So, if I make a will, when I die, I give all my estate to all my students. And then, if he makes a will, he said, when I die, I give everything to Mr. Wong. And then we die together, unfortunately, or happily. Then, if I and this gentleman die at the same time, the general rule shall apply. I must be older than you. I shall be presumed to have died first. So, the general doctrine of lapse comes in. I die first. In my will, I give everything to all the students, including him. All the students, including him, are beneficiaries under my will, and all of us die at the same explosion, and you guys just check your ID card will do. You guys survived me, and therefore, when I die, everything go to you guys. You guys die, and then my gift will become part of your estate. Then my estate shall devolve into the hands of the personal representative of all the students who die at the same time. Who will take it depends on the students whether die testate or intestate. Okay? Another example, okay, the second example, he died before, he make a will, give everything to Mr. Wong, and then we die in the same accident, both at the same time. Then the law will look at our ID card. Mr. Wong, they don't need to look at the ID card, look at my hair will do. Okay, Mr. Wong, you must be older. If you're older, you're presumed to have died first. If I die first, he make a will, giving everything to me. I am the beneficiary under the will. I die first, the general rule of Camorra apply. So I die before the testator. Doctrine of lapse comes in. Then my gift, his gift, I cannot benefit. And I cannot call in section 33 example as an exception because I am not his son or issue. So you can say, under the general rule of Camorra takes, well, since we die at the same time, then, well, unlucky Mr. Wong, you go to hell. Cannot enjoy the fruit of inheritance benefited by him to me under his will. Now, this is a general rule. What we want to talk about is a second Camorra takes rule. Is on the rule of intestacy. If I have a will and he does not have a will and we both die, then First of all, in my case, rule of intestacy does not apply because I die testate. Got it? But if he died without a will, we are dealing with his estate. Then we say the rule of intestacy shall apply to his estate, and then the rule of intestacy shall not apply to my estate. Reason, I die with a will. Reason, he died without a will. Now, extend this rule a little bit further. Since this is a general rule, this concept of older die first presumption will also apply on other kind of property ownership, such as joint tenant. Okay? Such as joint tenant. All right, now, go to this particular rule on intestacy. This narrow rule is only applicable if this is a case of a married couple. A married couple who died without a will. So this is only the only situation where we have this second rule of Camoran case. And this rule is applicable on intestacy and is restricted to the situation of married couples. All right. Me and my wife die together. In my will, I give to my wife everything. And then in my wife's will, she gives me everything. Then the doctrine of comorbidity comes in. General rules shall apply because this is a testate situation. My wife younger than me, so I die before my wife. My estate goes to my wife. Her estate does not go to mine. End result, both the estate of Mr. Wong and the estate of Mrs. Wong shall all devolve under the will and go to the wife, and shall be disposed of under the will of the wife. And yet, me as a beneficiary under the wife will be affected by the doctrine of lapse. Then who will take it? We don't know. It depends on the will. But what we know is this. This mutual benefit, I don't get no nothing. For two reasons. Number one, I'm older. Number two, we both die testate. Okay? Intestate situation is not the same. Intestate situation, the rule says, Section 4, subsection 11. So the rule says, when Mr. Wong died without a will, Mr. Wong is not survived, we both die at the same time. Mr. Wong's wife is younger. Then, it doesn't matter because age is no longer relevant. Intestate, the law shall presume the wife of Mr. Wong died before Mr. Wong. So there is a presumption of predecease of the spouse in the narrow rule of comorbidity that we are now talking. Got it? So, the rule of intestacy shall apply as if Mr. Wong died, survived not by his spouse. Then you go to the other items, from item 2 to item 8 that we had discussed last time, and to see who are having the next highest priority for inheritance. Similarly, the same logic applies to the estate of my wife, regardless the age of me. I shall be presumed to have died before the intestate wife. Same logic, but this time we look at the rule of intestacy from the angle of my wife. My wife died without surviving spouse, and then any issue, and then most important, parents on her side. So this is a significant rule of intestacy in order to bring about what considered as a fairer inheritance. They presume, even though a married couple without a will die together, there is no reason why the two estates should be benefited by parents of one side alone. So that is the logic and the rationale. Got it? So this is all we have discussed. That's all for lecture 5. I want to have an earlier break now because after the break we'll have lecture 6. Okay? Let's take a break for 10 minutes now.